this third session dedicated to about patent filing. So to deliver with regard to recent developments in patent filing, now may I request Ram Jawahar sir to give insights about patent design and filing procedure. Before that, let me take this opportunity to introduce our guest speaker, Mr. Ram Jawahar. So he's an assistant controller of patent and designs in the Department of Industrial Policy and Promotion, which comes under the Ministry of Commerce and Industry, Government of India. So he has joined this organization in the year 2003. Sir has examined and granted more than 10,000 new innovations. Uh, in fact, he is a mechanical engineer who obtained his double master program. So this is great to know that double master program, one from CEG campus, ME in internal combustion engineering, then other ME program from AC Tech campus, MTech, the MTech polymer science and engineering. So he has more than 4 years of teaching experience in the Department of Mechanical Engineering at the College of Engineering, Guindy, Anna University. Sir has completed several IP-related programs conducted by Geneva. The various programs Sir has successfully completed. In fact, Sir has also obtained a PG diploma course in the field of IPR. So he has been to Japan for 3 months to study the procedures on the systems practiced at the Japan Patent Office. He has also obtained a certificate course in German language from University of Madras. So Sir is having such a vast credentials in his credits. And now may I request Dr. Ram Jawahar sir to deliver his presentation in the field of patent design and the recent developments in the field of a patent. So now the session over to Ram Jawahar sir.
Sir, thank you very much for giving this wonderful opportunity. Thanks, Kumareshan sir. It gives me immense pleasure to talk before you. Today's topic, can I share my screen?
Yes, sir. Please, sir.
Yeah.
Ma'am, Shobha ma'am, please allow Ram Jawahar
Yes, sir.
to
Yes,
make
yes.
us a presenter, ma'am.
Thank you.
So because the numbers are huge, we have kept all the participants sharing and muting and control. I think now you will be able to share, sir.
Can you able to see the screen now?
Yes, we can see the screen, sir.
Yeah, thank you very much for giving this wonderful opportunity. So the today's topic is the recent developments in patents, filing and design. What all the new things comes in intellectual property office, all those things we are going to see. So the first thing is I have granted, sorry is rightly said, I have granted nearly more around 10,000 patent applications. In 2003, what I have seen, the situation is nearly around 20% of applicants are Indian applicants, and majority around 80% of applicants are the applicants from other countries, maybe from Japan, Europe, US, and other countries, Korean applicants. This was the situation before, but for the past 1.5 years, the scenario is slightly changing. So the recent record says that Indian filing rate is marginally overtaking the foreign filing standards. That's a great achievement. This type of achievements. It's only because of you people. So recently, the past 2 years, the majority of the applications are comes from colleges and universities. Most of the people, they are filing their project reports or their PhD reports. This gives a good rate, the increase in Indian filing applications. Okay, to file, the things to remember. First, you have invented something. What you need to do? What you need to do to file a patent? First thing, you need to check whether your invention is novel, inventive step, and industrial applicability. Kindly check these 3 important things. What is novel? Novel in the sense it should be new to the society. You are the first person introducing the product to the society. In the simple words, in the colloquial words, if you want to say novel means, I can be able to cite even a single document to kill your invention, to kill your novelty, to kill, it's not a patent. So the single document as such copied document, then that thing is called the novelty. And inventive steps, in the simple way to explain inventive step, in the sense, you can take one document from IEEE document and one document from other journal and other document from the US patent document, combining all three things and making a new patent document. In this scenario, what we will do is, we will cite all the three inventions and says that it is copied from these three things. In this scenario, it fails inventive step. And the third important thing is industrial development. Okay, industrial applicability, whether the invention has industrially applicable or not. So most of the applications may be industrially applicable and novelty may be there. So majority of the applications fails in inventive step. So they are combining 2-3 applications and making one single application and filing for patent. So this is one such thing. You please be careful about this ideology. And thing is, many people may think that whether the patent is really valuable, is there any scope for patent or not? There is so many questions that comes in their mind. I will tell you, I always used to say one example, that is the Kodak versus Polaroid. The Kodak is a camera, they have first invented this particular camera, but people advise them to go for a patent, but they have not interested in filing patent application. So many people advised go for patent, but they are not at all interested. But after some time, what happened? The Polaroid people, they somehow copied or somehow know about that invention and they filed the patent first. And after that, what happened? They issue the notice to the applicant. They filed, it's our own invention. The Kodak people copied. So it was difficult for Kodak people to prove in front of the court. Finally, the Kodak lose in the battle. The court has to pay such a huge compensation. So in this scenario, the patent is very, very important. And not only that, in today's world, there is so many startup companies are there. Many startup companies, they are making some beautiful products and they are running the company very well. So the government is giving many subsidies to startup companies. They are making lots of money out of their new product, but they never know that whether their product is patented or not. In this scenario, after 3 years, they receive a notice from original applicant. If they receive the notice from original applicant and says that it's my product without my knowledge, you are producing all these products, so it's a criminal offense means, then if they go to the court, what happens? Whatever the amount they earned is, they need to pay the, I mean, original patentee. So in this scenario, what are the works you done it for the startup companies becomes waste. So in that way, the patent is very, very important. There is a lot of difference between patent and thesis writing. In thesis writing is, that is no money involved in this one. The huge difference between this patent and paper presentation, main thing is the money involved. So patent, you can get a royalty. You make a beautiful invention. You please make a beautiful invention. Then you commercialize that invention and someone else is using that ideology and making some product means you just file a case against them, immediately you will get the royalty. It is an automatic process. If suppose somebody is doing without your knowledge, you can file a case against them. So court will ask them to file a royalty to you. So that is a huge difference between the patent and what can I say, the thesis, whatever the paper presentation or whatever maybe. So the document, in the sense, the patent office, the first thing is the patent office, where your location. If you are a South Indian, you need to file a patent only in Chennai patent office. If you are a north zone, your residence is in north zone, then you need to approach in Delhi. In west zone, you need to approach in Mumbai. East zone and northeast, you need to approach in Calcutta patent office. Okay, That is the thing. If suppose you are giving address, your residence address is Chennai, and you cannot go to Mumbai and file your patent. That you keep it in mind. So once you file a patent, then there is so many examiners are there, so many controllers are there. Your application may go to Delhi official, but you need to, depends on your domicile, you need to file in that. It's a regional specific. Okay, that is about the patent office. Then license, or you can give, assign your invention to someone else. Okay, you can give a license, or you can give a cross license. So one part to one company, other part to other company, or you assign your invention to somebody else. If you could not make a product, you don't have the money to run your industry. In this scenario, you can assign your invention to some other company. They, as a huge amount, you can get the money from the user, or as a royalty, in the form of royalty also you can get it. So in these ways, whatever happened, if something else is happened, means immediately you can approach the court. The previously the court called IPAB, Intellectual Property Appellate Board, but recently that is appellate boards are removed. If suppose you are not satisfied with our decision, you can go to, you can challenge our decision in the High Court. Okay, then you yourself can draft the patent application. There is no need to go to the uh, patent attorneys. Who is patent attorneys? Patent attorneys is the authorized person to write the patent document. For that, we are conducting an exam, that is patent agent exam. There are two papers are there. The first paper is an objective type paper. Second paper is patent writing. We test the applicants, I mean, test the people whether they are qualified or not. After that, we conduct an interview. Then we issue the certificate. These people are the certified patent agents or patent attorneys. Okay, that thing is also there. You can come through these patent agents, or you can directly file a patent in Indian Patent Office. Then you please understand your competitors. There are so many competitors out there. Many competitors are within you. So many people, once they file a patent, they come to patent office and they explain about inventors. And all the students says that, sir, we are all friends. We done this BE project. We are working together. Like that they used to say. So once the money involved, once a royalty comes into picture, then these friends become enemies. So they become the competitors. They file up. So in this scenario, there are many cases. The pre-grant apportions are there. The post-grant apportion procedures are there. Majority of the cases, your own people, your friends file the pre-grant application and post-grant application. Okay. So you please know about your competitors. That is very, very important. Then commercial players. Once you got a patent, how to commercialize your invention? So many people, they think that once I get a patent, just make a photography and frame and keep it in their room. That's not the case. The patent is, that's not the case. After that, you commercialize your invention. How to commercialize your invention? That is very, very important. That is the reason why, where to commercialize, which area to commercialize, where your product plays a big role. For example, some of the products, if you commercialize a product in Chennai, it may not work fine. But if you commercialize that same product in Europe, that may work fine. So you please find out the area where to commercialize your invention. Then general public can directly come to patent office. This is a patent related things. Before you file a patent, so three things you please keep it in your mind. The first thing is conduct a literature survey. The literature survey, of course, even in the paper writing also, the literature survey is must. The same type of literature survey you do. So literature survey can be done through, there are various research papers are there. In addition to research papers, in patent, what you need to do is, for the prior art search, some of the major patent office websites are there. If you go to Google and type EPO, European Patent Office, there will be the column. In that column, you please type your keywords in the particular column. Then what are the related patented inventions filed in European Patent Office that you can view. Or you go to USPTO. Go to Google and type USPTO, then European Patent Office. All these free websites only. So there also you can check. If you type JPO, Japanese Patent Office, then Japanese inventions will display. Or KIPO, KIPO, Korean Patent Office is also there. So all these patent offices are there. You can go to this particular patent office and check your invention. If you feel that it's a difficult task, means it's a simple thing to do these prior art searches. What can I say? That is Google patent. Just go to Google and type Google patent. That will take you to Google patent page. There you type the keywords. So a lot of inventions will come related to your prior art. Okay, related to your invention. So in India, the major problem is the duplication of research. So please avoid this duplication of research. Even in the project report also, many people, they say that that is a duplication. The 5 years back, the same invention was available. It was done by some other students. And this year, the same invention filed by. So these type of things, you please avoid. Okay. So duplication must be avoided. For that, what you need to do is, so without your knowledge, you may think that you are the first person to file a patent, but without your knowledge, someone might have published your invention in a German journal, or whatever, maybe some automobile journal, something else, it might be published. So you please check before processing your invention. So that is a prior art search. And what are the disadvantages of the prior art? That also you please found. You think that in this area, no more invention we can do. Like that, you don't go, don't involve in this mentality. Don't go in this mentality. So some of the disadvantages may be there. For example, if suppose some transmission system, means in that transmission system is well fine, it's well designed transmission system, we cannot do something more than, don't think like that. So in that one, what's a improvement we can do? Why the wear and tear happens? If you involve in the wear and tear portion alone, or the emission control portion alone. So emission is European norms, something else is saying, if you do the better emission standards, or if you whatever maybe, better conversion ratio. For example, the conversion takes place in, there is no perfect conversion anywhere. Some mistakes may be there. So you find out the mistakes in the prior art, you work in that area. So that also patentable. Okay, after finding out this prior art, so describe your invention. So write your invention in the plain paper, and what are the advantages as compared to the prior art? What are the advantages as compared to prior art? That you tabulate 1, 2, 3, like that you tabulate. Then you can understand what is the improvement from the previous invention or available invention. The improvement alone, you can go for patent filing. So what many people, some of the people, they may replace just the material. They can replace any parts of the invention with other equivalents. What are they? So if suppose they just change the material, whether it is patentable or not, then in this scenario, you please characterize, because of changing this material, my lifetime is increased. If you prove that, then that is also patent. You please characterize that that portion alone. For example, some people, even in metallurgy, the steel, they have done some invention. They just replace this with nitrogen steels. If you're using the nitrogen steel, then what will happen? The same strength you will get, but at the same time, your life also increased. So how it is interlinked with your invention, you please prove that one, then that is also patentable. So what are the equivalents and what are they? Provide one or more line drawings So line drawing is very, very important. If at all any of the 3D picture or whatever the drawings may be available, you use that one. And list of then provide line drawings or the flow, any flow chart if suppose you are having, that also you please present. And the business methods, pure business methods is not patentable, only the technical portions are patentable. And list of commercial advantages. So commercial, the word commercial is very, very important in patent. So the purpose of getting patent is make money out of your invention. So what are the commercial advantages of your invention in point form? So prior art and prior disclosure. So oral disclosure. So this type of things is always happening. If you are discussing the invention with your friends, so what happens? Those people, without your knowledge, they come to patent office and file a patent. This was a thing happened. One such inventor, he made a beautiful, that is a battery related cycle which has a very good advantages. So such advantages, once he made that product, what he did is he come to patent office and file the patent. So next day morning, what happened? Without his knowledge, someone introduced that same product in the market. That news was come in the newspaper. Okay, so what happened then? This person comes to patent office, sir, someone has filed. Then after that, he inquired his very close friend. He discussed the entire thing with his friend. That person introduced the product in the market. So then it comes to the case. So that person, fortunately or unfortunately, he didn't file the patent, but the original inventor, he filed the patent. So the case comes in favor of the original inventor. So even the oral disclosures or your good friends may many times become your enemies. So prior printed publication available to the public. So if anything, the prior public knowledge, that is reason why the people always used to ask, sir, Americans got patent for neem. Yes, of course, they got the patent for neem. After that, that comes to our knowledge. Our people file the case in the American Patent Office. It is our traditional knowledge. Our people are using this product for so long term. They submitted some Sanskrit literatures, all the Agatya literatures, all those things we submitted, and finally, what happened? The patent revoked. Okay, the patent revoked. So this also there is TKDL is the traditional knowledge digital library. There's something is available in traditional knowledge digital library, you cannot go for patent. So the first thing that need to do is the conduct the search and enlist the problems in the prior art. What is a prior art? Conduct search. Is there any problems in the prior art? You concentrate on this portion alone, that becomes a patented invention. And what is the problem sought to be solved by the invention? And what is novelty? Novelty, I already told you. And what is the solution to obvious? Obviousness is nothing but inventive step and ascertain the type of application, whether it is a complete specification you need to file or provisional specification need to file. What is the difference between complete and provisional specification? If suppose you are doing a research, you have not conducted your, you are not completed your research, but you are in the mid stage, but you know that you are going to get this type of results. So in this scenario, if suppose someone from other countries, if they file a patent, means you will lose the priority. So you file a provisional application. So within 12 months time, you can file a complete specification. First thing is provisional specification, then 12 months time limit is given. So in the meantime, why you are filing the provisional specification is you are predating. Okay, the date of filing provisional, from that day onward, before that day, anybody done that same invention, we cite those citations. So if someone else files a patent or any, papers after that provisional specification filed date, that we don't cite. So that is the reason why the provisional specification is very, very important. But keep it in mind, within 12 months time, you file the complete specification with entire solutions. Okay, all the solutions. If suppose you could not complete the these things in 12 months time, then some forms are there. You can post date this one for another 6 more months. That is also there. Then decide the area and the nature of protection. The Paris Convention is there, PCT application is there, and ordinary application is there. What is this ordinary application? Ordinary application in the sense, if suppose you invented something, you come to Indian Patent Office and filing a patent. You come to Indian Patent Office and filing the same day we give a documentation and the application number, date, time, everything will be printed. Everything will be printed in this form. Okay. So that day is your priority day. That is your ordinary application. Okay. You think that after that, so my invention has a value in other countries. Why can't I go to other countries? Why can't I go to other countries? In this scenario, under the Paris Convention, the application called convention application. Within 12 months time, you can go to Europe or any country, US, Japan, or China, or any country, you can file a patent. So within 12 months, if you file a patent and quoting your convention application, quoting your first filing date in India, then your priority starts from original application in India. You can keep your priority. That type of application is called convention application. And one more type of application is there. That application is called PCT. PCT is nothing but Patent Cooperation Treaty. As per the PCT, all these things are happening in WIPO, World Intellectual Property Organization. What is World Intellectual Property? The head office at Geneva. These WIPO, there are nearly around 152 countries are members. So there are nearly around 152 countries are members. If you file a first ordinary application, then within 12 months time, file an international application. Then we will forward your application to WIPO. So WIPO will forward your application to all the 152 countries. So all the 152 countries will contact you, file your application in their countries. So you need to pay the particular fee and file those application in the respective nations. So here the PCT, what the advantage you are getting is from the priority date and PCT filing completion date, there are 31 months time limit we are giving. And in convention application, the time limit what we are giving is only 12 months. But in PCT application, you are getting the advantage of 31 months time limit. Okay, 31 months time limit. So the time limit is very, very important. That's what we always used to say. Who is the inventor for telephone means everybody used to say that Alexander Graham Bell. Okay. So what happens in American Patent Office? He come to American Patent Office in the morning, but same day afternoon, the person called Elisa Gray, he approached the patent office. But now he worked the invention in somewhere, but Elisa Gray, he worked in somewhere else. Those people are not copied. But the timing is today nobody knows about who is Elisa Gray. They know only Alexander Graham Bell. Just because of 3 to 4 hours lag, the 4 hours lag, there is nobody knows about who is Elisa Gray. The people know only about Alexander Graham Bell. So like that, there is the so many things are there. Like who invented? If I ask you the question, who invented radio? There also the same type of things. Will Marconi invented radio? But after that, Tesla, he says that all these things are my inventions. He has copied. Like that, he sued the in the U.S. Court, and he died in the year 1939. Then this person died in the year 1942. After the death of this person, the judgment came. 6 months after death of this person, the judgment came. What are the properties he was holding? Now the Tesla is the original owner. Like that, that judgment has come. There is so many case studies are there. So the time limit is very, very important, because of 3-4 hours, other person got a patent, right? So the modes of filing patent application, once you are doing some PhD work or whatever, maybe you want to protect, don't delay the period. If you are delaying the period, that is your biggest enemy. And some people, they come to me and ask that question, sir, I have already filed the, what is that, paper presentation. In IEEE, I have already, in SAE journal, I already filed this one. So what will happen? So in patent, in the sense, you have to come to patent office first. Don't file anywhere. But if at all, you file the patent, I mean, you presented paper in some conference or in some journal, you published your invention, within 12 months time, you come to patent office and file a patent, means we don't cite your own invention as a citation. Okay. Else what will happen? If you come after 12 months time, then you file a patent. So your own invention will become your enemy. We cite your own invention and we will say that it is a published document. So within 12 months time, very, very important. So if you are in the research state, please go for a provisional application, and 12 months time you file a complete specification. These are the section 29 to 34 that talks about this type of when to file a provisional application. And prior public, for example, the communication to the government. One inventor, he made some beautiful product, but before filing the patent, he communicated to the government and says that, sir, I have made such a wonderful invention. That one will not become the citation. That one will not become the citation. And some, what are maybe some conference or some exhibition, you presented your invention. So whatever you do, within 12 months time, you come to patent office and file a patent. That's a lot of difference between the provisional. Even you are in that research stage, you go for a provisional application. Once your research completed, you go for a complete specification. Okay, maximum 12 months time. So when there is an urgency, the provisional application, you may feel that there is a beautiful market outside. Someone may come in between. That time you file a provisional specification and commercial disclosure. What is the commercial value for your invention is there, and submission of thesis and inventors and seniors leaving the company and accidental disclosure and many competitors. In this scenario, you please go for provisional specification. Okay, provisional specification is a must. Okay, so what are the things in provisional specification? So substantially, it will not be examined. So automatically it will lapse from the filing date within 1 year time. So within 1 year time, you please file a complete specification, and the priority date is very important. You will get a priority date. So applicants can use the patent pending. If suppose they make some product also, in the product they printed says that it is patent pending, cannot claim the priority from the another application. Only the description record. No, the drawings are optional. So main difference between the provisional specification and complete specification: in provisional specification, it does not contain any claims, but in complete specification, it contains claims. The structure of writing claims is very, very important. The claims only value your product. So, but before writing the claims and all these things, you please keep it in mind. The section 2, section 2 of patent office, patent act, it is novelty, inventive step, and industrial applicability. But in section 3 of the patent act, what does it say is, what are the things is not patentable? For example, please keep it in mind, anything, the perpetual motion machine, any invention which is against a well-established natural laws, any invention against well-established natural laws. If suppose the thermodynamic equations are there, second law of thermodynamic is there. You make some inventions and says that my output is more than input. If someone is come to patent office and says that the output is, it's not at all possible. So those type of things, for example, the perfect example is a perpetual motion machine. So continuously existing machines is not at all possible. If someone is comes to the patent office and says that I have done a perpetual motion, so we don't grant patent. So this is section 3A of Indian Patent Act. Please keep it in mind. And the second thing is moral. The moral value is that any invention that is, what can I say, the method of mixing masala powder with brick powder. So nobody can found. This may be the good invention. That machine can mix, sir, these two things. Maybe but it is not patentable because the morality is not there. So these type of things are not patentable. And one more thing is there is pure abstract theory. Section 3C says that abstract theory or mathematical modeling, only the mathematical, we need some product. Only the mathematical modeling is not patentable. And other thing in electronics related people, the 3K, section 3K, which says that pure software programs, the many people make a pure software program. Pure software programs are not patentable, but the software coupled with hardware is patentable. In which way it is coupled? So if it is coupled with hardware, it is patentable, but pure software programs are not patentable. Then you may ask the question, sir, why the company called TCS, CTS, and Infosys, all these people having the separate IPR cell? Because as per American Patent Act, even software programs are patentable, but Indian Patent Act says that pure software programs are not patentable. So what they need to do, they file a patent in American Patent Office. But as an Indian citizen, he cannot directly go and file a patent in other countries. They need to get a permission from Indian Patent Office. If you are an Indian citizen, you come to patent office and one form, section 39, form 25 is there. With the form 25, you file the application and present your invention. Then within 2 weeks time, we give a permission from the patent office. Then using that permission letter, you can go to other countries and file a patent. So some people ask a question, sir, can I directly go on? As per the act says that the mathematical modeling, of course, the mathematical modeling is not patentable. The pure mathematical modeling is not patent. Anything we need some product is very, very important. So many people recently come to patent office and says that, sir, I have got an Australian patent, the innovative patent. Yes, of course, some people within 2 months time, if you file a patent in Australia, within 2 months time, people will give innovative patent. They don't check novelty. They don't check inventive step. Once you file, they give that certificate. So that is not valuable one. So someone else is challenging, then they do novelty and inventive step. In Australia also, the standard patent is there. Standard patent, they check everything. But in innovative patent, they don't check. And one more thing in Indian Patent Act, as an Indian citizen, you want to file any patent in outside India, you should get permission from Indian Patent Act, Indian Patent Office as per section 39 and form 25. If you are not getting permission from Indian Patent Office, that also a criminal offense. Okay. Many people think that, sir, nobody is watching, but your enemy may be there within you. If he writes a letter to us, then some legal issues will. As an Indian citizen, you need to get permission from India. Once you file a patent in India and using the priority date, you can go. Or with form 25, once you get a permission, then you can go. So without even informing Indian Patent Office, if you are directly filing a patent in other countries is a offense. Okay. So in provisional application, the description record, and drawings are optional and need not provide any claims. So provisional application will not be published. Only the complete specification will be published. So the complete information is not recommended to the the inventor and applicant details, and what is the crux of the invention, in which area you are working, in that area, what is the characterized portion of your invention, all those things in some rough text you can file. So that one is considered as a provisional specification without claims. Okay. You completed your provisional specification. So 12 months time is about to over. That time you can go for a complete specification. So what is this complete specification? So what are the portions the complete specification must contain? The complete specification must contain, first thing is your title of the invention, then field of the invention, which field. So for example, you are doing some invention in some engines, in the sense, some emission control in engines, in the sense, my invention focusing on internal combustion engineering, particularly on this emission equipments, and more particularly of emission related gases. So this type of thing is your field of invention. And next thing is uses. Because of your invention, what is the use? Then third important thing is prior art. This prior art portion, you please go to the patent office website or any country's patent office, any invention which is close to your invention, you please present those inventions crux point, and as compared to the before we are citing the invention. Okay, many times the examiner cite the invention, but before that it is recommended in the prior art you cite those invention that is very close to your invention. So that invention you please cite. And what is the difference between the closer patent application and your, what is the advantages as compared to the prior art and your invention? That thing is very, very important. And drawbacks of the prior art, and what are the drawbacks in the prior art, all those things you please mention in that portion. And a comparison between these prior art and your invention, that will be helpful, because you yourself disclose what is the closest prior art. Otherwise the examiner will cite those thing as a citation. That's a better option. Then summary of the invention, just write the summary, the main crux portion of the invention. Then don't include the drawings inside your complete specification. You please keep your drawings separately at the last pages. You please write the brief description of your drawings. Brief description of your drawings. The figure 1 says like this. The figure 2 says like this. So how it is interlinked. The parts 1, 2, 3, 4. Those representation, the top view, side view. So all these things you can represent in the complete specification, and detailed description of the invention. So these are all the things very important. And in addition to all these things, the portion called claims, the claims is very, very important, because the based on your claim only the value of your invention stands. So wherever you go, how the patent has some value, that is so many websites. IndiaInnovates.com is there, Srishti.com, the website is there. They are valuing your invention. If your invention is very good invention, the people will fund for your invention. IndiaInnovates.com, then Srishti.com, and even in Tamil Nadu state government, entrepreneurship development cell is there. In entrepreneurship development cell, previously they were giving 1 lakh for your invention. If you get a patent, they are for commercialize your patent, they are giving 1 lakh. Now they increase to 2 lakh rupees. Even Tamil Nadu government doing this entrepreneurship, and science and technology ministry also funding for your inventions. So all these things are based on your claims, the value will be given. So after the claims, you please make abstract. You please make your abstract maximum of 150 words. Don't make abstract more than 150 words. Then if you have any drawings, After the abstract, you please make a drawings and sequence listing. The sequence listing for biotech applications, the sequence listings are there. For example, if it is a mechanical applications, what the citations is, the section 3, there is one column called arrangement and rearrangement. Okay, if two, three parts are there, you just coupling. For example, the famous example we used to do is umbrella fitted with the fan. If you lift the umbrella, then one fan may be fixed. There may be the battery switch is there. Once you press the switch, the fan will rotate. The umbrella operation is different, fan operation is different. This is mere rearrangement. So the best example, arrangement and rearrangement, and how to escape from these classes. For example, if you are driving a car, if you put a right indicator, the right indicator blinks. So after that, in the previous, in ambassador cars, if you make your steering straightens, your indicator will not comes to rest. Your indicator still blinks. Then manually you need to switch off the indicator. But today's world, the scenario is different. You put a right indicator, then make your steering straightens, automatically your indicator comes to rest. When the indicator comes to rest, so this type of, that is interlinking with each other. This one is patentable and the previous one is not patentable. So previous one is not patentable. So here they used to say that famous story, the person, his name is Nakamura. He worked in a company called Nichia in Japan. This person is the first inventor in LED, blue LED. So he is an ordinary worker. The company made lots of money out of his invention. Company made lots and lots of money out of his invention. Then he asked for, sir, it's my invention, you made crores of money. The company given just 20,000 yen to Nakamura. The 20,000 yen is nothing but 10,000 rupees. Then he approached the court. What the court said is, in the court they says that before joining this company, he signed in the agreement and says that what are all the inventions you make, the inventions belongs to the particular company. Like that, one agreement he has signed. Wherever you go, without your knowledge, you might have signed those agreements. But court given a beautiful judgment. Even though you have such an agreement, the value of the invention is more. The amount you gained is more. What the compensation you given is very, very less, just 20,000 yen. So court asked the Nichia company to pay such a huge money to Nakamura. So he got that money and he resigned from the company. Now he settled in US. So this type of, there are so many case studies are there. So these type of things are there. So make your complete specification properly. So complete specification must have title of the invention, field of the invention, use of the invention, prior art, drawbacks of the prior art, comparison of the prior and invention, and summary of the invention, brief description of drawings and detailed description of the inventions. If suppose you are making some invention that contains uranium, thorium, plutonium, anything, these type of materials, we refer your application to BORG. So any inventions related to defense, so we will send your application to DRDO. Once we get clearance from DRDO, then only we process your applications. So once you file application today, what we'll do? So application must contain Form 1. Form 1 is about the details of the inventor, and Form 2 is nothing but your complete specification. Then Form 18 is also required. That is called request for examination. That's a must. Within 48 months time, you need to file request for examination. But the day one also you can file the request for examination along with Form 1 and Form 2. Okay, if you file these three applications, then what happens? Your application will be published in government journal in 18 months time. So 18 months is such a huge period or long term. So to avoid this one, the Form 9, the class is introduced. What is this Form 9? The Form 9 is express publication. So once you file a patent application with Form 9, the Form 9, you have to pay the extra fee of 2,750 rupees. If you pay this one within 1 month time, that will be published in Government of India Gazette. Once it is published document, then you can immediately carry out your experiment or you can commercialize your product. So the published document will be eligible for the examination. There is a reason why today is the previously it takes 3-4 years to get the first examination report. But today's case, it's not that. Because of Form 9, within 6 months time, you get the first examination report. Okay. So writing the description, the title, maximum of 15 words. Don't use more than 15 words, and indicates briefly the subject, the field of the invention. So based on the field of the invention, only your application will allotted to the particular department. In patent office, there are 4 departments are there. One is called mechanical department, another one is called electrical department, biotechnology department, and chemistry department. So based on this one, the computer will automatically read the field, and it will allotted to this particular field, particular group, and also it allot to the subject specialist. So each and every subject there is a specialist is there. It reads the invention. So this one will go to the specialist. So after field of invention, the background or prior art that indicate the existing problems. What are the problems exist and available solutions in the journals and patent specifications, how your invention solves the existing issues. Okay, this is your background of the prior art and brief description. What is the drawings? The figure 1 illustrates the constructional features like that. You please use the word. The many people, many of the Indian patent application, they fails because of that preparing this techno-legal document. So you can practice in this area. You can also prepare these technical documents. So brief description in the sense figure 1 illustrates the constructional features and what the flow chart contains. That description must come to the complete specification. Then detailed description. So describe the invention with reference to drawings and provide us what are the advantages and technical solution to the problem. Technical solution to the problem of the prior art. That itself is a biggest prior art. Avoid pronouns, nouns, and personal stories. So some people even in the claims portion they write personal stories. I am the inventor. I have found out this. What the struggle I faced. So all those things in many specification we used to say. So please avoid these type of things in the complete specification. Only the technical matter. Don't use your trade name in the title. For example, you may have some trade name may be there. Don't give these trade names in the title. Okay, avoid the pronouns, nouns, and personal stories like. So these claims, the claim drafting is very important. Every complete specification must contain at least one claim. Without claim, it will not be eligible as an invention. The people never grant the invention without the claims. So at least one claim is required. So difference between the description and claims. The purpose of the patent is to convey the public what the patentee considers to be the invention. That's a description. But what the monopoly he has chosen to obtain, that comes in the claims. Okay, that comes in the claims. The many people they use, I am the inventor of the apparatus, and no one shall use the invention without my consent, and machine described above new, not used till date. So these type of words, majority of the Indian applicants uh, we happens to see. Please avoid these type of things. Only the technical matter. So for what portion the first thing for making a claims, what portion protection is required, what is the legal basis of protection, and define the area of technology. And second principle is different categories of invention. Learn how to draft different categories of invention. So the claim portion is considered to be the prior art. That is one type of claim is called a two-part claim, and another one is called Jepson claim. So whichever is appropriate, whether the Jepson claim is appropriate or two-part claim is appropriate, you please choose and draft the broadcast and strongest possible claims by carefully choosing the right words and add the dependent claims to specify the many claims whenever appropriate. And Marcuse type of claim. What is this Marcuse type of claim? This is mainly used in chemical inventions. It allows a single claim to define alternatives of the invention. So if you are making some chemical related or chemistry related inventions, then you please practice this Marcuse type of claim. So unity of the invention is must. So every claim must depends on the first claim. The unity is very, very important. Otherwise, we ask you to go for the application called divisional application. Okay, sometimes you file the patent. Then after that, you may think that, oh, you work on the same invention, some improvement, if suppose you are getting means, in this scenario, you go for patent of addition. That possibility is also that you can go for patent of addition. Then the structure of the principal claim, the preamble, and transitional phase, the body contains invention. So main thing is for the mechanical and electrical and these things, the characterized portion, the uniqueness of your invention. So one claim, the first claim contains preamble plus the transitional phase, then body, and characterizing portion is your invention. So some people may use the comprising of, like that they can use. But for mechanical related inventions, we ask the people to characterize your invention. The claim should always contain single sentence. Don't use multiple sentence in one claim. Single sentence having commas and punctuations. Okay, every claim should have called the preamble. Preamble is very, very important, and the preamble should consist in the scope of the claim, and title should be similar to the preambles. Okay, thereby, so usually you use the words like it should include the body of the claim, perhaps in whereby. So these type of words you learn and you use. So some people, the claim body is materially affects the claim. The most common transition is my invention comprising of. In some invention, if you see, it says that it is comprising of, and some invention it says that it is consisting of. What is the difference between the two? The term comprising means including following elements but not excluding others. So it's a broad claim. So you might have seen in the claims, the comprising means it including the following elements, but not excluding others. So that becomes a broad claim. Other equivalent terms for this is including, having, it containing. These are all the other ways of representing the comprising. So it's a very broad portion you are getting protection that some people may use. In the inventions, you might have seen it is consisting of, means the following elements. These are all the elements I am using, but no more or no less. Only this, as such this. So you are very much precise. So in this scenario, people may use consisting. Okay. Other equivalent forms of consisting, they can use the composed of, it constituting, being. These are all the major difference between the comprising and consisting. The scope of comprising term is broader, whereas consisting is narrower. So the scope for comprising, it's something like making a broad claim, and whereas consisting is a narrow and precise, and it's a limited scope. Okay, the term consisting essentially is in between the comprising and consisting. So the claims contain main claim or principal claim. Then other claims are the dependent claims. Other claims as claimed in claim 1, whereas these type of things are recorded, that is in dependent claim. And one or two independent claims may be there, and application claims. And previously we allow this omnibus claim, it's a lost claim, but now we are not allowing this omnibus claim. Okay, as a mixture of all these things. So one claim set means it contains principal claims, dependent claims, and only one application claim. Application is nothing but a use claim. Okay, we allow only one application claim, dependent claims and principal claim. So the claim drafting, there is a two-part claim method is there. Another is, I already told you, the claim is called the Jepson type of claim. What is this Jepson? It is a improvement type of claim. Is an improvement and inventor claim stating that a preamble describing a prior art or transitional class, wherein the improvement comprising the description new or modified elements. The improvement from the previous one. In this scenario, you practice Jepson type of claim. And Marcuse type of claim, I already told you, it is mainly used in chemistry related inventions. Set of similar compounds may be claimed as a one group or recommended for chemical, biological, pharmacology, pharmacological and ceramics, refractory, metallurgical compositions, even mechanical, the fastness selected from the group consisting of. So even sometimes it's used in the mechanical inventions like the fastness, where it is selected from the group consisting of staple, nail, screw. So here also this one is used. So it's some model claim. A is a name for the preamble is describing. It's comprising of. Okay. For example, the emission components of internal combustion engineering comprises emission part 1 and emission part 2. So part 1 in the sense what are the things there in the emission components, and you whereas one element A is there. So A has what are the sub elements of A, that limitations, and element B, it has a sub elements, but how it is connected to A. So this way you can practice your claims. Element C connected to A on B. This is that relationship is very important. ABC has a relationship, whereas C has a sub elements. So this way you draft your claims. Okay, this way you draft your claims, and the subsequent claim. The claim 2 is actually the dependent claim. The preamble, the name in the sense, the same preamble will come as claimed in claim 1, wherein the element C has more sub-elements or limitations, more sub-elements, and apparatus claim. Apparatus includes machines, devices. For one example is there, apparatus for shaking articles comprises a container, a base, plurality of parallel legs, means of oscillating the container. So these are all the apparatus claims. Okay. And you can use, for example, you made one apparatus. So the process and method, and usually write in apparatus claims because they have fewer elements. So method of operating that particular machine. The method alone is patentable. Even in some inventions, the process alone is patentable. They write only the process claims. They write only the method claims. So that thing is also patentable. So article of manufacturing claims. So essentially the same apparatus consisting of a combination of elements named tied together in the mechanism. Most rules of apparatus apply, however, allows the article manufacture patents for kit unassembled parts. So you unassembled all the things and each portions, then how it is related to each other. This type of explanation is a typical way of writing patent claim. These are the chemical claims, the chemical composition, zinc, electroplating solution comprising. So, for example, zinc, the aqueous solution of zinc acetate from 30 to 90 grams, 1.5 to 3 times. It's not precise, but sometimes what the claim drafter will say, sir, my range is from 30 to 90 grams, and particularly of this range, and more particularly of exactly 55. Like that, he can draft the claims. For example, how one model we can see, ice surging machine. So this type of machines were used in the temperate areas or the areas where it is the Scandinavian countries. This type of machines are so common. So what if suppose you invented this machine? So how you draft the claim? For example, the part 1 is the blade. The purpose of the blade, the surface. In the road, the ice completely covered the road means these machines used to remove those ice particles. So blade saves the surface. That is the first one. Then second part is collecting. After the horizontal screw, this is the second part is gathering the savings. What all the ice collected, it gathers its second part. And third one is water is fed from the wash water tank. It is for washing. And then clean with a hot water spread ice towel behind the condition. This is the renewing. So if you are making this type of, you made this type of machine, then you please present this type of drawings and how make claims for this type of inventions. So the simple way of explanation is what are the elements present? Vehicle. In the vehicle consisting of, there are 3-4 parts. One is major part in the vehicle are ice scraper, ice chip collector, wash and vacuum, and wipe and finish. So it has 4 arrangements. For example, someone might have got the patent for ice scraper means, then don't worry. If you make some improvement in the chip collector, that also that portion you characterize. Or the wiping portion alone, if you do some invention, that portion alone you characterize and you can make your invention. So first thing in the vehicle that consisting of ice scraper, ice chip collector, wash vacuum, and wipe and wash. Then again, you make a drawing like this in the ice scraper. So what are the type of ice scraper? Bevel and its width, angle, and what is its height. So those things involved in ice scraper. And ice chip collector in the sense whether it is a horizontal, vertical, or storage dump. These things are the subparts of the ice chip collector. And wash vacuum. Wash vacuum in the sense here in the store clean, spray clean, how the washing is happening, vacuum dirty and store dirty. And in this one, the wipe and wash, cues and hot towel. So these are all the sub parts of the vehicle. So vehicle which has the major parts like ice scraper, ice chip collector, wash vacuum, and wipe and finish. And further it is divided into what type of ice scraper, bevel, width, height, and what is it angle. These things we can represent. So for example, the first claim, it consisting of these are the things. What's the purpose of ice scraper? What the purpose of chip collector, wash vacuum? We make it as first claim. Then bevel type, that it depends on the ice scraper, how it is related with each other. This is a way of drafting the claims. So make a tabular column, vehicle, ice scraper or saver, on horizontal conveyor, vertical conveyor, wash and vacuum water, wiper, skews. Okay, if it is a vehicle means what type of vehicle it is? It may be self-propelled or four-wheel drive or steer from back, and driver and controls the back and holds a chip container, water container. So these are ice scraper means what is a width, what is a height, what is a cutting edge, leading edge, trailing edge, collects the leading edge. So these things, for example, the width, the vehicle height, these things may be known to the public. So ice chips collects the leading edge. Their invention means that alone you can characterize. And horizontal conveyor. What is our what are the features available in the horizontal conveyor? Horizontal conveyor, it's helical screw and edges to center outward and forward scraper and collect ice chips from the blade. And vertical conveyor, outlet ice chip container, helical screw chain with paddles in old version. And vertical conveyor, it has a helical screw and chain paddles. So whatever may be, all these features, you please make a tabular column. Wipes away excess and contains water pool and trailing towel with hot water and trailing skew. And these things you please make it as a features and writing of the claims. So ice surface containing the device comprising the scraper plate and ice saving collector. So how to draft? In this type of invention means how to draft. So the ice surface conditioner device comprising a scraper blade having a cutting edge for, so everything in single sentence, please keep it in mind. So first thing, scraper blade, that's a comma, then semicolon. So where it comes, you please note down. And engagement with an ice surface and ice saving collector in communication between ice saving container. So these collector having an inlet adjustment blade and outlet and communication with an ice saving container. This is your first claim. So this way of making, you please practice in this way. You can easily make a patent applications. There is no need to go to the agent. So some people may feel that if you file the application through agent, he may charge you more money. In this scenario, there is no need to approach the patent attorneys. You can directly draft the claims. You can practice in this way. You can draft your own application. Okay, then the claims in the sense the claim 2, 3, 4, 5, these things are the subsequent claims. These claims, what type of, for example, ice surface container device as claimed in claim 1, the ice saving collector comprises horizontal conveyor. So this is a preamble. Ice surface containing device as claimed in claim 2. So third claim is depends on first claim. So like that. Here, the eighth claim, you please read. The ice surface containing device claimed in claim 1. So it depends on the claim 1 comprising the water coating distributed rearward of the blade. So like that, the preamble, then according to claim 1, wherein from where it is depends on. So this is a way of making the claims. So for example, if you are making a rice cooker, what is the object of the invention? Cooking rice. What is the preamble? Apparatus for cooking rice. Suppose he knows that that is extended for grains. Then apparatus for cooking grains. Suppose he further knows that can be used for vegetable and melting cheese, etc. Then apparatus for cooking. So somebody invented one pencil with the eraser, and in the middle, the pencil has a light. Then what is the way of writing? Apparatus comprising a pencil and eraser attached to one end of the pencil and a light attached at the center. And better way of saying the same one, pencil having an eraser wherein the improvement comprises a light attached to the pencil. Okay, so this is a way of writing the patent claims. Writing the instrument attached to one end. The instrument is claimed in one, wherein the second claim. How the second claim depends on first claim. The instrument is claimed in claim 1, wherein the eraser firmly fixed and attached. Wherein the third claim as claimed it, wherein the eraser is firmly attached by method selected from the group consisting of the chemical and mechanical attachment means. Okay, this is a way of writing your subsequent claims. Okay, for example, if you are in the chemistry field, how to write a claim? The composition, for example, some chemical, the chemical is comprising 40% of A compound and substantially the equal proportion, that is the 40% of compound B and compound C. So this way you can write, or the composition comprising 40% of A, 30% of B and 30% of C, or composition comprises 30 to 50. In this way also you can write 30 to 50% of A and substantially equal portion of B and C, and 40% of A and substantially equal portion of B and C, and composition comprising 32 and A, B, C are in equal proportion. So which one suits you? This manner you can choose and do the. So out of this, which has a broadest protection? Broad claim in the sense the composition comprising 30 to 50% A and substantially equal portion of B and C. Because of the substantially equal portions, this has the protection. It's a broad claim because it's actually the broad area we can say. Okay. So this is in electronic field, a portable audio file of storage and playback. It consisting of, here he is not saying comprising of, consisting of predetermined number of RAM memory, predetermined number of electronic input, and predetermined number of the same claim. You can write it like this. So which one has the broad means the plurality. You use the word plurality. The portable audio file storage and playback device comprising a plurality of RAM memory spaces and plurality of electronic input and output jacks. Here, the scope is more. Okay, this is section 10 of the Patent Act says that how to draft this complete specification. Even in the complete specification, not only that, in biotechnology nowadays there are so many inventions are coming. So even the gene decoding. So why the disease affects a person? Because of your gene. So recently, I think you might have read in the newspaper in biotechnology. I think that is one company called Myriad. This company that decode the gene called BRCA1 and BRCA2 gene. What is this BRCA1 and BRCA2 gene? If suppose the lady, these two type of gene present in a, if you go for investigation, if a lady has BRCA1 and BRCA2 gene, the invention says that 100% chance of getting breast cancer. 100% chance of getting breast cancer. So this is an invention. Based on this invention, the company made crores of money. How they make money? That is this because of, you might have heard about Angelina Jolie. Angelina Jolie, she opted for this particular test. Angelina Jolie, she opted for the particular test, but unfortunately, that is BRCA1 and BRCA2 gene present in her body. Then what the result suggested, 100% chance of getting breast cancer. So immediately she opted for double mastectomy. So she wrote one book about her experience. After reading that book, all the ladies in US stood in the queue to opt for that test. So yeah, if you go to US, only the treatment procedure you can get medical insurance for the test, not for the testing procedures. So once all the people stood in the queue, then during this Obama period, Obama, he changed that act called Obama Care Act to new act. That time, the testing procedure also he has included. The cost is around 4,000 US dollars. So why I'm saying this thing is, in biotechnology, these type of inventions are coming. Because of these inventions, the company made crores of money out of these type of inventions. Okay. What are the copies? The filing the documents and copies. The Form 1 record, Form 2 record, Form 9 record, and Form 18 record. And drawings. You make a drawing as per the Rule 15. Okay. This is about the patent filing procedure. I'm not telling about how the see what all the advantages and disadvantages. Those things I'm not concentrated in the today's lecture. I concentrated only on how to make a patent application without visiting the patent attorneys. If you practice this area, you make you draft your own invention. Okay, this is a way of making the patent applications. So it's almost only 10 minutes time left. If anyone wants to ask questions, you are welcome. You can ask questions. So last 10 minutes, I'll.
Yes. Sir, good afternoon, sir.
Yeah, thank you. Yeah,
Sir,
please.
this Kumaresan,
Yeah, please, sir. Please,
I,
sir.
I have one question with regard to pattern.
Okay.
Sir, there are like different pattern types are there, like the design pattern, how it is different from the standard pattern, sir.
See, there is nothing like a design patent. One set is called patent, other one is called design. What is this design? In patent, in the sense that all the technical specification will come into picture. Design in the sense there is no technical specification. For example, you make one glass. So please take a photo of top table or side view. You design of is available. So if you file the application, application to
Sir, your voice is breaking, sir.
Calcutta specification and climb. It's just a
Sir, there is a discontinuity in your reply, sir.
Involved in design application. Only it's a aesthetic application. That
The simulations can be patented.
Difference between
Ram Jawahar sir,
question, sir?
we are not able to hear your voice, sir.
I think sir is facing some network issues.
Yeah, yes.
Sir, maybe we can just quickly summarize and ask for any other questions from participants by the time sir joins.
Yes. I think since the sir, but sir name is appearing right in the screen.
He's very
We can
much
able-
there.
Yes. Ma'am, have you said about okay? Meantime, you can say about the patent conditions what we follow at university towards the submission of synopsis and thesis. Did you inform anything?
No, sir. I just told them that if it's an awarded or a granted patent, instead of the research paper, they can submit it for their synopsis. Not much about it. If students are having any doubts regarding this, you can now ask. Professor Kumaresan is also there, and Ram Jawahar sir also may be able to explain it to you. So some participants must be working in this particular area where they are innovating some products or some designs. So in that case, if you are planning to do something, I think the participants should ask now.
Yes. Meantime, Ram Javagars are also able
Sir,
to join.
there is a question in the chat box.
Uh,
Can you open and see it, sir, or shall I read it out for you?
Chat box. Yes, ma'am. The question at 3:24 p.m.
Yes,
Right?
in
Someone has
architecture
asked,
field. Yeah.
you usually work on the design process. I think Ram Javagars are also can see this question. Is there any possibility we can file a patent for the design process? That's about my name.
Psychology.
Yeah, I think just now sir said for the design patent alone, right? That is not a kind of standard patent, right? Considering design pattern alone, right, that is not sufficient to submit to the scholar synopsis or thesis. Okay, but to give more insight about this question, I think Ram Jawahar sir, ma'am.
Sir, he has left the meeting. He's not in the meeting.
Okay, fine. Shall we conclude, madam?
Yes.
Right. Okay, fine. Okay. See, thanks. Though the Ram Jawahars are not in the meeting now, I sincerely thank Dr. Ram Jawahar sir for his wonderful talk about the procedure behind the pattern. Okay, sir has come. Sir, Ram Jawahar sir, ma'am, you please unmute. You ask our
Yes.
the person
Can
to
you please
unmute.
unmute? Yes, he has unmuted.
Yes, sir.
Ram Jawahar sir.
Yeah, I can hear you. Some technical
Yes,
problem
sir.
happened
Sir,
here.
you just click on the chat box, sir.
Okay.
I think that there is a question at 3:24 p.m. One scholar asked about the architecture field. Can you able to see the question, sir?
No, sir. What is that question, sir? Can you please?
Yes, sir. Can I read, sir?
I can't see any question. Yeah. Can you please read that?
Yes, sir. In the
Only
architecture, okay, the question goes on like this. In the architecture field, we usually work on the design process. Is there any possibility we can file a patent for the design process if it is not supported by any product or a hardware?
In the architecture field, we usually work on the design process. Is there any possibility can file the patent in the design process if supported by the product or? Sir, usually you in the architecture field you can go for a design application, and for making that process, what is the method used or what is the process used, the steps? The steps also you can go for patent.
Okay.
Sir, at
But,
240, there is another question from one Mr. P. Muthukumar.
Okay.
The question is, sir, if mathematical modeling is not patentable, what else is the way to patent? Because mathematic modeling may be useful for design of the equipment. Kindly explain.
Yeah. The mathematical modeling alone is not patentable, but along with the product, it is a patentable. So mathematical modeling is there. You please make some product. So with that product, how it is coupled with the product. So in this scenario, you can go for that is a method of operation. Draft a claim like that. Method of operation of this one like that. You please draft a claim. If you directly present the mathematical model, it is not patentable. Some abstract theory, computer programs are not patentable. But when it is coupled with hardware, it's patentable.
Thank you, sir. I hope Mr. P. Muthukumar has noted down the answer that sir has said. Sir, there is another question from one Mr. Reno Infanto. Is patent filing a chargeable one? So that's the doubt of this particular scholar.
Yeah, but patent filing, the cost is nothing but the Form 1 as an individual citizen, the cost is around 1,750 rupees. And Form 2 is a complete specification, no cost. And Form 18 is 4,400 rupees. And Form 9 is 2,750. Total cost is 8,900. So previously for individual one fee structure, in the company name means the fee structure is triple time. Like that it was there. But the company name now it's same. But if you are filing in the college name or university name, then the fee structure is same as individual. The recently 3 months back in the cabinet that amendment has made. Even you can file application in Anna University name, then also the same fee structure of individual. And one more thing is there in the patent, that is expedite patent application. This expedite patent application, there is no need to come in the same queue. If suppose you are in a startup company or one applicant is a lady, then you can quote this class. You can apply this one in expedite patent application that you need to file Form 18A. So another 10,000 rupees extra you need to pay. If you do that, there is separate queue you need to come. So the patent procedures will completed in 1 year time.
This is something like a fast track process.
Fast track process, correct.
Thank you for the clarification, sir.
This is Muthukumar.
Yeah, please, sir.
Sir, I'm Muthukumar. Again, I have a small doubt.
Yes, sir.
So already one equipment is available in the market.
Okay.
They are applying their technical design and all, and they are designing that equipment and they are manufacturing. Now I want to they say again, which is related with the mathematical modeling only. I am doing a mathematical model. And I am writing the design equations how the in another means analogous system. For example, the system is designed in their mechanical formulas and all. I am making an analogous system and I am modeling that with the equations and all. And finally, if I am changing some variables in my analogous parameters, then I can design this mechanical like that. If I want to do something, then is it patentable or not?
No, it's mostly the analogous system. We need you make a method different or the process different. Only the analogous alone means it's very difficult to get a patent.
Okay, sir. Okay, sir. Okay.
Sir Ramjagar, sir.
Please, sir.
Sir, I have one question. Like recently, we came to know that in Australian patent there are like a innovation patent and invention patent. Invention patent. There are
Yes,
two categories: innovation, invention. This innovation patent, there are many scholars. They obtained innovation patent from Australian patent office, but they give this patent within a month.
Yeah, correct. True.
Within a month, without examining those patent, they are granting. Okay, what is the difference between these two? Innovation patent, whether they can claim those patent?
No, sir. No, sir. Yeah. whatever the thing you give in to Australian Patent Office in the name of innovative patent, they don't check novelty and inventive step or industrial applicability, nothing they will check. They just give the patent grant certificate. Okay, so many people giving that certificate here, whether that is having the equal value of other patent means it doesn't have equal value. In Australia, one more patent called a standard patent. If you go
Yes.
for standard patent, then it is valuable. For innovative patent, whatever you write, they don't not even read. In some format it is there. They don't check novelty, inventive step. They just give the this certificate. So
Okay.
someone else's challenges, then only they go for novelty and inventive step. It is for getting some numbers. The people are getting this innovative patent. I don't think that any value innovative patent has. Even someone is produce innovative patent in Indian colleges or companies also, it does not have any value.
Okay. Are we giving such kind of patents, sir, in our Indian patent system?
No, sir.
Is there any innovation patent and
No, sir. No, sir. Yes.
Okay.
No,
Fine.
sir. Recently, even in some WhatsApp also, people saying that we are getting utility patent. We are
Okay.
getting utility patent like that. Some group is functioning. There is
Okay.
in India so far utility patent is not yet granted. I mean,
Yes, sir.
that is not yet introduced. I can say that not it is in the discussion stage only whether we can
Yes,
go for utility patent or not.
Yes,
So,
sir.
but someone is wrongly spreading the news and says that we are getting it a utility patent for you, like that they are spreading news and getting patents and collecting money. These type of things are happening. There is no such utility patent available in Indian Patent Office.
Fine, sir. Okay. So, thank you, sir. Thanks for your wonderful lecture on this Indian patent system and what is the procedure to apply for patent. And your lecture definitely helped a lot of our scholars how to proceed with their idea, how to compile the patent or how to apply the patent to our Indian Patent Office. Really, it was a very wonderful lecture, and I hope this is like the huge area within
Yes.
this short period, 1.5 hours. It is highly impossible to cover all the informations with regard to the patent. I hope our center, the future workshop and the induction program, we will try to arrange the further like
Yes, sir.
such kind of a talk. We'll invite again to deliver much more information with regard to patent. Thanks a lot for your lecture, sir, and also the thanks for accepting our request to deliver within a short period. You have accepted our request. Once again, thank you for this on behalf of Center for Research. So I thank all the participants for their patient listening. Thank you.
Thank you very much, sir. Definitely, I will come directly and deliver the lecture. That will be better and reach many people instead of giving lecture through online. So that may be better. Definitely, I will come there, sir. Thanks for your invitation. Thanks a lot.
Thank you. Thank you, sir.
Thank you, Kumaresan sir, for moderating that session. And thank you, Ram Jawahar sir, for your lecture. Yes, Director Madam, would you